Chair,
Morena.
we have one other person, Anne Kendall, who will introduce for us.
Can you hear me?
Yes.
Okay. Morena, tēnā koutou katoa, the Chair, Deputy Chair, and members of the committee. Thank you for hearing us. I am Anne Kendall. I am co-chair of the New Zealand Māori Council. On screen are the Council's PO, or patron, Sir Taihakune Jury, the Secretary, Donna Hall, and the lead researcher, Dr. Betsy Martin. I will introduce you to the Council and to Sir Taihakune Jury, who alone will speak to the submission. The New Zealand Māori Council is a statutory body that has been constituted under the various statutes dating back to the Māori Council Act 1900. Its unique feature is that it represents hapu as the traditional governing entity of Māori society. But with changing demographics, the Council today represents both traditional and modern Māori committees. Its current statute is the Māori Community Development Act. It strives to make government aware of the community opinions and communities' awareness or aware of government policies. It operates through 16 district councils and 138 elected Māori committee groups. The Council has assisted the development of treaty principles through many proceedings in the Supreme Court, starting from New Zealand Māori Council versus Attorney General, recorded in the 1987 New Zealand Law Reports. Sir Taihakune Jury, who has been a judge since 1974, was chair of the Waitangi Tribunal from 1980 to 2000 when he was appointed to the High Court. The foundational principles of the treaty were developed during his tenure, and I will now pass the rako to Taihakune Jury.
Thank you, Anne, and Chair and members. My name is Taihakune, and I am from Ngāti Kaupapa of Manawatu. The Council opposes the bill, but welcomes the debate. I will make just 3 observations. The first is that the bill ignores 50 years of examination of cases that inform the principles of the Treaty of Waitangi by well-qualified Maori and Pākehā of the Waitangi Tribunal, which in my time had 50% Maori and Pākehā, and by senior judges of the High Court, the Court of Appeal, the Supreme Court, and the Privy Council. Numerous governments have not sought to challenge those findings. They have been the subject of regular reports to the United Nations, and they align with similar findings internationally. My second point is that the principles of the treaty, as described in the bill, do not, in fact, reflect the purposes and intent of the treaty as recorded in both treaty texts. They are not, therefore, treaty principles if they do not emanate from the treaty.
No.
There is an extraordinary ignorance in presuming otherwise. If this bill were to pass, I believe that our government would be the laughing stock of those of the Western world who understand how responsible states today seek to manage relationships with their Indigenous people. Mr. Chair, those are my only observations. We are actually more interested in your thinking than our own, and I would like to use the rest of this time for questions.
Kia ora Taihakune, thank you for your submission. We'll go to questions from Joseph Mooney, then Duncan Webb, then Steve Abel, then if we've got time, Amy.
Tēnā koutou katoa. Look, I was just interested in reading your submission where you discussed Principle 3.1 about everyone being equal before the law, and that you pointed out in that submission that this actually came from the Magna Carta. And you don't say this in your submission, but that principle that the King and his government are not above the law. Have you read Archdeacon Henry Williams' letter to Bishop Selwyn in 1847 where he said he thought that the treaty was the Magna Carta for the Aborigines of New Zealand?
I haven't read that particular one, but I've heard that comment quite often, that the treaty is the Magna Carta. But I think what the Magna Carta was really trying to do was to preserve the rights of all people. And that is also what the treaty is trying to do. It is trying to reserve the rights of Maori that existed prior to the Europeans being here. So the objective was to provide for both peoples.
Thanks,
Sorry.
sir.
Oh,
No,
yep, sorry, Mr. Chair.
Mobile. And we'll take subs through the chair as well. Thank you, sir. We'll go to Duncan and then Stephen.
Kia ora, Rangatira. Read your submission with real interest. There's one bit I'd like you to comment further on. You talk about the treaty being a series of promises by the Crown to Māori, and you infer that there are therefore things that Parliament, the New Zealand government, doesn't have the authority to do. Can you explain how you see the treaty as essentially a constraint on Parliament's authority?
Yeah, I think in that context, we really have to talk about parliamentary sovereignty. I believe it's a very outmoded concept. We should not be talking about it in this day and age. Sovereignty means that one has all power to do everything. Now, that may have suited the people who lived in the 1900s, but I do not think it can be a proper approach for our times, where we must be talking not of parliamentary sovereignty, but of parliamentary responsibility. So that if we look to Israel, for example, we can say that Netanyahu could have all power. It's not the point in this day and age. The question is, how can he best achieve things on a responsible manner of acting? The next point is that governments are all constrained. Donald Trump is constrained by the American Constitution. It was the American Constitution that got the American people through that dreadful attack on the Senate. You are immediately constrained when you have a constitution, and we do have a constitution. You are constrained when you enter into or sign up to a provision of the document of the United Nations. You agree to behave in a certain way. There is nothing unfamiliar with the fact for lawyers that governments are constrained in some way. And yes, this treaty was putting a moral constraint on the government as to how it would behave.
Kia ora.
Thank you, sir. I'll take one final question from Steve Abel.
Yeah, just you speak about equality and equity. How do you respond to the use of a rights principle, equality, when it has been used to remove rights from Indigenous Maori?
The big thing I think is when we talk of equality, the essential thing is the acknowledgement of difference. If we are to work together and proceed as a people, we must respect how communities differ from one to the other. We must respect the difference that able people have from the disabled, that men have from women, and different cultural groups that exist. So to talk of equality creates a real problem if we so focus on it as to believe that all people are the same when all people are not the same.
Thank you, sir. Thank you for providing your submission quickly this morning. We do appreciate your time being with us.
And Eddie.
Folks, we're going to move.
Well, that definitely was a more constructive.
Which one, Sam?
Sorry.
Oh, I thought the video was still playing in the background.
Oh,
Thing.
okay.
Well, that was very interesting,
Okay.
wasn't it?
Very I'd say constructive, and it's interesting the bits that were brought up, which I think some people miss. I do like Steve Abel's question though, was about how do you claim about was it giving was it giving people equal rights when you're taking Indigenous people's rights away?
Yeah.
That really put a good part there, because taking someone's rights away isn't giving everyone the equal rights. It's you're taking something that they previously had and like confiscating it.
Right.
Just relate.
Okay.
Yeah, exactly. And what a lot of people need to realize as well is that there is a difference between equality and equity. Like, if someone gave me $1,000, I'd be extremely happy with that. I need that $1,000. If someone gave, say, Christopher Luxon $1,000, he'd look at it as pocket change and go, what do I need that for? That is equality. Giving people what they need to get them onto equal footing with the rest of the population is equity.
And a good example of that was women's suffrage in 1893.
Yes.
Even though I wouldn't call it full equal suffrage, because of the fact that, women had the right to stand for mayors and stand to become councillors, they still did not have the right to stand to become an MP until the 1920s. But they had the right to vote for the MPs, ironically. Yeah. Now, there's another one that you've highlighted was it Te Kanawa Wilson's speech, and it will need translating, which is probably where Jordon's going to come in.
Yes, we're going to need you for this one, Jordon.
Don't drop out. But it's all right. I've got a Zoom to sit down there and actually get to it because it's free. It's 3 hours, so I'm going from about 1 hour 30 to 3 hour 30 mark.
Yeah.
Right. So that's just before me, I think.
No. You're in the
after me.
afternoon. That's a different stream.
Yeah, 3.5 hours.
We did the one that was in there that was it Common Grace Aotearoa?
But it was it was before the church, after the church. Dr. Ganesh Nana had his kōrero.
Oh, right, yes.
325, which